conscripts, about 5% of the Nagorno-Karabakh army. And that, you will appreciate, ladies and gentlemen, that these two governments have forces poised in military readiness. And there are limits to which the applicants can act as stalking horses for the Azeri military and finding out information about other forces. But we have produced evidence that confirms that that is the limit of service in Nagorno-Karabakh. 1,000 conscripts doing their 2-year national service, not in any position of significance in the Nagorno-Karabakh forces. There is not a single unit of the Armenian army in Nagorno-Karabakh or the occupied territories. That is our case, and we are prepared. You've seen the very distinguished generals and ministers who confirm it. It was the applicants originally suggested that the court, if it decides that they're absolved from exhausting domestic remedies, should go on location fact-finding. And we would very much support that. If this court is minded to make a determination on effective control, please come to Nagorno-Karabakh through the agencies that were used by the court in the Cyprus and Turkey cases and in other cases. It's quite wrong, in our respectful submission, for the court to decide effective control without going and hearing the evidence, hearing it cross-examined, examining through its investigative methods. The problem we have is that the applicants and the interveners have relied entirely upon hearsay, upon politicians' statements, on misstated data like Mr. Chiragov. It was amusing and in a way, and sad in another way, that a leading NGO said that 10,000 of the Nagorno-Karabakh Defence Force came from Armenia. And this was footnoted, although the applicants didn't say so, this was footnoted to Mr. Grigorian. Well, we actually tracked him down, and if you read his statement, you find that he didn't say or mean anything of the sort. He says in his statement that you can't say because it's a military secret, and that anyway he was talking about Armenians ethnically and not Armenians from Armenia. So that is the kind of misstatement, the kind of propaganda statement that we are faced with. It's not evidence. Evidence comes from people who are prepared to say, I know of my own knowledge that this is the case, and I'm prepared to come and face examination over it. Not footnotes, footnote after footnote. Charles Blandy. Who is Charles Blandy? He's an old British soldier who seems to be working for not a world-famous organisation, who's made this statement about the Nagorno-Karabakh Defence Force, having never gone to Nagorno-Karabakh and not giving the authority for the statement. And this Charles W. Blandy is set out as evidence that it's got a lot of Armenians. This is not evidence at all. This is not the way courts should conduct themselves, or should be asked to conduct themselves on the basis of names, without any kind of knowledge of their experience, of their competence, of their expertise. We've put bodies in front of the court in the form of witness statements and witnesses who are prepared to say, on oath if it's possible, that their statements are true, that there is not one Armenian unit in Nagorno-Karabakh. There were 30,000, remember, Turkish soldiers in northern Cyprus. It was a military occupation. There is no military occupation. You may have noticed the statement by that courageous lady who has been for so many years, since 1990, worked for an NGO in Stepanakert with Azeris, and her independence of the Nagorno-Karabakh government cannot be in doubt. And she said, there's no question. There are no Armenian troops on the streets. There is no Armenian control of Nagorno-Karabakh. I should make clear, it's been suggested that we want the court to adopt the ICJ approach to effective control. We suggest that, but it's not, we haven't nailed our colours to that mast. We succeed on any view of effective control because the statements from the Nagorno-Karabakh authorities show that Nagorno-Karabakh is independent, that it is not occupied by Armenian forces. It is not, as the interveners suggest, a puppet state. It is a genuine de facto government elected democratically, observed by European observers to be a democratic country, to be democratic elections, and we have put up the independent evidence of Mr. Harry Bercu-Marcu, who is a Romanian expert, military expert, and he's given a very long and authoritative report confirming there is no control by the Armenian government or armed forces over NK or its defence army. The latter is independent and professional and under independent command. Dr. Bercu-Marcu is, of course, willing to assist if any fact-finding exercise is taken. Of course, they talk in their evidence, it's full of stories, press clippings about military exercises, parades, attendance by leaders at each other's celebrations. This is exactly what could be expected of friendly neighbouring states united against a common and sabre-rattling enemy. Wherever countries have military alliances, you find these shared training sessions and parades and so on. So in terms of our case on effective control, we say that the status of forces agreement, which provides for conscripts to serve part of their time in the other army, doesn't for a moment place Armenia in effective control. The fact that that agreement requires Armenian courts to punish misbehaving Armenian conscripts serving in Nagorno-Karabakh is common to status of forces agreement. America has status of forces agreement with most European states requiring that disciplinary matters be under the American prosecutors. It's a reflection of the fact that Armenia takes responsibility for the behaviour of its conscripts wherever they are serving. So the less important matters pointed to by the applicants, the All-Armenian Fund. This is a charitable organisation so that the diaspora can build roads, hospitals and schools. Exhibit L by the director, statement by the director of the fund, says we wouldn't get as much money if anyone thought it was under government control. 25% of the members of the board are from the government. But he says donors generally choose their own target, to choose what they want their money to go to. So it can't be suggested that this gives, and the United States pays about as much to Nagorno-Karabakh. It can't be suggested that they have effective control through charitable deeds. As for passports, we've demonstrated the issuance of passports to NK citizens is only done in certain specific circumstances through a highly formal process, by no means as of right. It's a humanitarian gesture because NK passports are not internationally recognized. Karabakians who need hospital treatment abroad, who are in the Olympics, and need passports to compete, are given them. On the issue of political ties, well, that's unsurprising, and it's not a basis for excess of jurisdiction. So far as the evidence is concerned, the Lechin judges and police chief and constitutional authorities all say that they are independent, that Armenia has no influence. The OSCE investigation, which is Exhibit L in our 2013 submissions, they went there, the OCSE, and they concluded that Armenia exercises no control over the locality. So, finally, we've focused, of course, on the issues, the jurisdictional issues that the court has asked us to look at. If it's undecided, if it's against us on domestic remedies and considers extraterritorial jurisdiction as a possibility, we request it, as the applicants did, to undertake a fact-finding exercise before deciding that Armenia has effective control, because that will show it hasn't. So far, finally, as the victims are concerned, victim status is denied, and those admitted contraventions and confusions in the victim's evidence alleged victim's evidence can only be decided by the at first instance. So, to conclude, let me merely say that in this case Article 35 is no mere technical legal bar. It can offer a way forward for this intractable conflict that diplomats can't solve. There can be no peace in this area without local justice. If Azeris, like the applicants and like Mr. Zafarov and Mr. Aleyev, who succeeded, can go to local courts and receive justice from independent judges, they'll see the rule of human rights overcoming the raw hatreds of ethnic war. That is what this court should encourage and supervise. The claims of Azeris being fairly tried in Yerevan and Stepanakert, and the claims of Armenians being fairly tried in Baku. Then and only then can justice, local justice, conduce to peace. Armenia and Nagorno-Karabakh have independent judges, courageous lawyers and public defenders. They want to be given the opportunity to show that they can do justice to the claims of the applicants. And then and only then, with the court playing its true supervisory role over domestic courts as the guarantor that they'll do right, can the fears and suspicions engendered by this wretched conflict be put to rest. The rights of the most vulnerable are best protected, as Eleanor Roosevelt once observed, by local courts, domestic courts, supervised in this case by this court.
Thank you, Mr. Robertson. I call Mr. Asgarov.
Mr. President, on behalf of the intervening state, the government of Azerbaijan, Mr. Malcolm Shaw, QC, will speak on jurisdiction, and Mr. Gabriel Lansky will cover the issue of remedies.
Mr. President, members of the court, it's a privilege to be before you again. I have the honour to appear on behalf of the Republic of Azerbaijan, the intervening state. This case is about three things: jurisdiction, jurisdiction, and jurisdiction. It is at the heart of this seminal case, and the court will have to determine whether or not a significant part of the internationally recognised territory of one contracting party, occupied in reality by another contracting party, remains within or is excluded from the protection of the European Convention on Human Rights.